Good morning, everyone. Welcome to our webinar for today, Understanding and Selling Employment Practices Liability. My name is Anae Agostini. I'm CEO of CID Insurance Programs, and I want to introduce our instructor today, who is Tim Nolan. He's a CPCU, an RPLU. He's a solid EPL underwriter with USLI. I also want to mention that Dan Mulligan, our professional lines underwriter, is on the phone with us. And then who's not listed here is Jacob Cole, who's our marketing specialist who works behind the scenes to make sure these webinars go well. So with that in mind, let's just hit some logistics and the objectives, and then I'll turn it over to Tim. All right, so what's our objective? We've got one main one. Retail brokers, we want you to learn how to best communicate the importance of EPL to your clients. And this is not always an easy thing to do, so Tim's going to help you with that. Let's talk about logistics. Everyone is going to be muted. You'll be able to hear but not speak because there's so many of you. But your voice is really important. We want your questions, and you can pose those, type those into the chat room right to the right on your little panel. And you can do that throughout the webinar so that we can answer them in the moment that they come in. And then just remember, there'll be a short survey, and we really would appreciate your feedback. So Tim, I'm going to let you get started.
And hey, thank you very much. My name is Tim Nolan, as Anae mentioned, and I've been doing EPL for about 6 years now. It's a really interesting marketplace right now. It's been changing more than ever, especially in the past 5 to 10 years. A lot of things have been going on. It's very dynamic. So I'm excited to be here today, and I appreciate all of you for attending. So we'll jump right in. As far as our agenda goes, our common goal: grow our business together. You know, a rising tide raises all ships, and right now, 25% of businesses with under 100 employees currently don't carry EPL coverage. So there's a ton of opportunity out there. EPL's never been in the news more than it has been today. So the awareness is really out there as well. So we'll touch on a little bit more of this going forward, but a few of our agenda items are going to be a little bit of an EPL overview, coverage features, a little opportunity assessment, and then we'll wrap things up with ease and speed of quoting. So what is EPL? Employment Practices Liability is a relatively new form of liability insurance. The first policy hit the market in the mid-90s. It provides protection for an employer against claims made by current employees, former employees, or even potential employees like those going through the application process. It covers allegations of discrimination, wrongful termination, sexual harassment, and other employment-related complaints, such as wage and hour violations or violations under the Family Medical Leave Act. These allegations of discrimination, harassment, and wrongful termination have increased dramatically over the years, especially in the past 10 years. And there is no sign of it plateauing anytime soon. The costs of defending these claims have dire financial consequences on businesses. With EPL, especially with small businesses, it tends to be more of a frequency issue rather than a severity issue. However, that doesn't mean these claims aren't expensive. They can be quite severe, as a matter of fact. Even the frivolous ones, if not handled correctly, can really balloon. But it can also just be a death by 1,000 cuts scenario without the proper risk management techniques in place. We'll talk numbers more in a minute, but the cost of defending even a frivolous claim can still be very expensive. Depending on where the insured is located, we're spending about $15,000 to $25,000 in defense costs simply to defend just the frivolous claims. So what is EPL in regards to exposures? Where do these EPL exposures come from? So the primary source for EPL exposure is derived from federal laws like the Fair Labor Standard Act and the Family Medical Leave Act. One of the most commonly cited federal statutes is actually Title VII of the Civil Rights Act of 1964. This act is what created the protected classes. That is, it prohibits discrimination on the basis of race, color, religion, sex, national origin, and pregnancy. So you may be thinking, all these statutes were developed decades ago. The Fair Labor Standard Act was part of FDR's New Deal. So why did EPL not enter the marketplace until the 90s? Well, from 1964 until Title VII of the Civil Rights Act was amended in 1991, those claims were always brought before a judge. Historically, when presented for a judge, the awards were given to the plaintiffs were far more predictable, and the severity was a lot more manageable. It was just sort of easier to tell how these claims would play out. In 1991, the law was broadened, and plaintiffs were now allowed to bring the complaint in front of a jury of their peers. So with a poor, sympathetic individual arguing their loss of income, maybe losing their house due to the termination from a wealthy company, there became a risk of an emotional decision from the jury. And so these circumstances led to EPL claims becoming a lot less predictable with potentially very large payouts. Companies had a major exposure due to these uncertain outcomes, and so the insurance industry sought to alleviate that risk, hence the first EPL policy entering the marketplace. It's important to note that state laws are typically broader versions of federal laws. For example, the federal minimum wage right now is $7.25 per hour, whereas in some states or municipalities it's much greater, even $15 an hour in some cities. This makes the burden on the employer that much greater because they need to keep up with all these laws that are constantly changing. And if they have locations in multiple states, they need to be familiar with each state's specific law. And here's just a picture of a business owner that forgot to purchase their EPL coverage. So a little bit more on what is EPL. Third-party EPL coverage addresses claims made by non-employees against the insured that arise from acts committed by employees. They can be customers, vendors, clients, really anyone who is not an employee. And they're generally going to allege some form of discrimination or harassment. We had one claim. This is a real claim that USLI received, where the CEO, the CFO of the insured consulting firm hired his 80-year-old mother-in-law to sit in the reception area and greet people as they came in. Well, she developed a friendly, or so she thought friendly, relationship with a UPS delivery man. All of a sudden, he stopped coming around, and shortly thereafter, they filed a hostile work environment and harassment claim. What we ended up finding out was that the receptionist was singing a song, and I'm going to butcher this, but bear with me a little bit. The song was something to the extent of "Who wears short shorts?" Something along those lines. When the UPS driver would come into the office, we ended up settling about $40K to settle the claim. And ultimately, the reception had the best of intentions, but as we know, miscommunication can happen, and it led to some uneasy feelings on behalf of the UPS driver. In this example, because we have an employee interacting with a non-employee who is making the complaint, we have a third-party harassment allegation. And because the insured did indeed purchase third-party coverage, the claim was covered. Had they not purchased this third-party coverage, the claim most likely would have been denied. So here's some things to consider regarding the cost to the employer. Simply put, these claims are very costly. The average, sorry, just one second. The Insurance Journal put out a study a few years ago that an employer is actually more likely to have an EPL claim than a general liability or property claim, which is crazy when you think about it, because all those employers certainly have a property and GL coverage, but now are only starting to recognize the need for EPL. And general liability policies typically will exclude EPL, or if they do, they may include it as an endorsement. However, it tends to be very low limits, like 10 to 25,000. And it's really watered down coverage. Typically speaking, it's just going to be coverage for discrimination or harassment with no other extra coverages like third-party coverage or wage and hour. Furthermore, attorneys and employees out there are aware of this. It used to be where you could see billboards or hear commercials that say, have you been injured in an accident? Call ABC Law Firm and get paid now. In recent years, though, states have capped what can be paid out for personal injury cases. And there's been somewhat of a shift away from personal injury and more towards employment practices lawsuits. Now we're seeing billboards and commercials saying, are you owed overtime or back wages? Call ABC Law Firm and get paid now. To that end, the additional attention and advertising dollars have led to an increase in employee awareness. The cost to employers. So simply put, these claims are very costly. The average time it takes to process an EEOC investigation, that is an investigation by the Equal Employment Opportunity Commission, is 229 days. These claims have a very long tail, which means lots and lots of billable hours by attorneys. The average defense cost alone for defending an EEOC claim charge is around $15,000. And 16% of claims that are seen in court have over $1 million in settlements. And the average cost to defend an EPL claim that goes to trial is $150,000. So as you can see, litigation is very expensive. As I mentioned, we're spending anywhere between $15,000 to $25,000 to defend a frivolous claim. A frivolous claim would be one with no evidence or basis in any kind of discernible fact. And not only that, but 81% of all the claims that we see are actually deemed frivolous. So to put it another way, there are a lot of small businesses out there that are doing their best to be good employers and do right by their employees, and yet still get hit with unnecessary lawsuits that would bleed them dry if not for EPL coverage. Just some claim trends. Over 40% of EPL claims are brought against private employers with under 100 employees. So two things to consider here. One, it's not just big companies that are getting hit by these EPL claims. They all do. And not only that, but these smaller to mid-sized types of companies don't have the money and resources to spend on HR departments to avoid or mitigate these risks. And it really doesn't take much to put small companies out of business. 60% of discrimination cases settled by jury verdicts are in the favor of the plaintiff, and the median jury award is about $250,000 plus possible punitive damages being assessed. So really, it's really expensive to litigate a claim. Just three types of claims that are trending right now that I'd like to touch on briefly. One is going to be wage and hour lawsuits or FLSA violations. What these mostly look like are failure to pay overtime or failure to pay minimum wage or adequate wages. For example, we had a chain of fitness centers that were sued by 20 current and former employees who were required to work through lunch and break periods. This time was later counted as unpaid by the employer, and the employees were awarded a payout in the hundreds of thousands for the unpaid hours worked. One thing to note about these violations is that they can often affect an entire workforce rather than a single employee. So they can potentially turn into class action lawsuits even. And small companies will typically lack the resources to prove they pay their employees correctly, so it can be very difficult to defend. Next is a drive-by ADA claims. These are also called tester claims. This is where a law firm will drive by a business open to the public to see whether they are compliant with the Americans with Disabilities Act. USLI saw this in the form of a group of hotels in the state of Georgia. What was happening was a lawyer was driving with his nephew who was in a wheelchair up and down the freeway, and they were stopping at every Hampton Inn, Clarion Inn, Motel 6, and they were looking at the swimming pool. What they were looking for was this apparatus that would allow people with disabilities to get in and out of the pool. If the hotel didn't have this apparatus, they were filing a third-party ADA discrimination claim for violations of the Americans with Disabilities Act. These types of claims typically aren't too severe, but like I said, they can also be a death by 1,000 cuts type of scenario. And lastly, probably one of the more recent types of claim trends that we're seeing are ADA website accessibility lawsuits. The precedent has been set that the American with Disabilities Act extends to technology or websites. And so if a company has a website, it must make accommodations for people with various impairments to fully access the website. This is an interesting development because the exposure is pretty difficult to measure. Really, any company with a website is a potential defendant, and anyone with a disability is a potential claimant. USLI just incurred a spate of these claims recently. One example was a bowling alley in North Dakota. The owner of the bowling alley had his son create a website for the company as part of a school project. It was a very bare bones, no frills type of website. It literally had one of those counters at the bottom with a dancing bear. Soon after putting up the website, they were hit with a lawsuit because a person with a hearing impairment was unable to fully access the website. Like drive-by claims, these tend not to be too severe, but the frequency can really add up. And so now I'd just like to touch on some of the primary coverages of an EPL policy. These are going to be somewhat specific to a USLI policy. However, most EPL policies in the marketplace will have a variation of these coverages to some degree. One of the most important coverages we provide is wage and hour coverage or coverage for the Fair Labor Standard Act violations. We offer a sublimit of $100,000 for both the defense and the indemnity for these wage and hour claims. Our coverage is unique actually because most other carriers will only cover defense actually. While we don't offer this in Florida or California, and I recognize that some of you listening may be from are probably listening in California, please note that we are duty to defend. And so what that means is that if a wage and hour claim comes in along with a covered wrongful act, we'll defend the whole thing. So while technically we're not offering this coverage in California, we pay out more in wage and hour claims in California than any other state next to New Jersey. Next is defense costs outside the limits of liability. So a USLI policy is defense costs outside the limits and they are uncapped. This is very important because as we kind of mentioned, the defense costs can really accumulate over time. And you don't want these legal fees eroding the limit to pay out any indemnity if the insured is then found liable. If you have a tough plaintiff attorney, these defense costs can really add up fast. So with a USLI policy, you can sleep soundly knowing you'll have the full limit for any award or settlement. Next is duty to defend, a little bit more on duty to defend wording. So what this means is that we will assign panel counsel that specialize in employment practices litigation, so they know what they're doing. And we have a duty to defend that claim regardless of how frivolous or baseless it may be. The next is the hammer clause. We have a 75-25 hammer clause in favor of the insured. So in the event that we are able to reach a settlement, but the insured would prefer not to consent to settle, perhaps they feel like they've done nothing wrong and they really want to see it through, we will continue to defend the claim. However, 25% of the costs in addition to that settlement amount will be on the insured. USLI will still take care of the 75% though. Next is full prior acts coverage. This provides coverage for wrongful acts occurring prior to the inception date of the policy. This is important to keep in mind because when you think of discrimination or harassment, it's unlikely for the wrongful act to occur one day and then the claim to come in the next. It often occurs over time. Therefore, if the applicant does not have full prior acts coverage, wrongful acts that occur prior to the policy period may not be covered. We offer this in most states and will match the applicant's expiring EPL coverage in the state of California. And then finally, punitive damages. We offer punitive damages where insurable. So punitive damages are meant to punish a defendant for egregious behavior. So there are a handful of states, though, that do not allow insurance to indemnify the insured. The reason being is that the idea of punitive damages is they're meant to punish or penalize the insured. California, for example, is a state where punitive damages are not allowed to be insured by a carrier. However, we offer, to accommodate this, we offer most favorable venue wording, which means that if the insured is based in California, but let's say has a location in another state where we are allowed to pay the punitive damages, we will indeed pay those damages provided the claim is brought in a jurisdiction where we are allowed to pay those damages. And just to kind of give you a little bit of idea of some underwriting considerations. There's a list below, and these are all these are very important to the underwriting process, but a few in particular I wanted to touch on. First and foremost, we're going to be looking at the type of business. So some types of businesses lend themselves to higher than average EPL exposure. For example, we tend to see higher claim activity in restaurants relative compared to, let's say, an accounting firm. There's a variety of reasons for these, but typically high turnover and less formal work environment are good indicators of a higher EPL exposure. Location is also very important. Specifically, location based on state. California, for example, is far more employee friendly than, say, a state like Utah, which tends to be a little bit more on the employer side, relatively speaking. California has a higher minimum wage. They have stricter laws on what constitutes an employee versus independent contractor, and tougher employer compliance requirements. Utah, on the other hand, is a little bit closer to the federal guidelines. For these reasons, the EPL exposure is greater in California than Utah, and thus, all things being equal, a risk in California will be rated higher than it is in Utah. And then just the last one would be the employee count. This is what the premium is rated off of, as employees are going to be your primary claimant. So the more employees that you have, the greater the EPL risk and the greater your premium is going to be. So what are you doing to sell EPL? Do you currently include EPL quote in every risk? One thing that USLI tries to do is be as accessible as possible, and so that you have something to provide, at that time when you're at renewal, so you can offer that alongside the GL or the property quote that you have. Are you having success? What percentage of customers purchase it? And are you offering EPL, or do you believe you are really selling it? If the answer is no to these questions, feel free to reach out. We can certainly provide additional marketing pieces or webinars like we're doing right now. We are always more than happy to provide follow-ups to these to really drive home the need and the understanding of this coverage as it becomes more and more prevalent and important in the marketplace. The typical sales model. The producer offers EPL as part of the quote, but is not really sold. So the one thing that we've noticed is that it's somewhat unusual for an employer to kind of just all of a sudden go and buy full-blown standalone EPL policy. They usually kind of dip their toe in the EPL market with this add-in throw-in endorsement on like a BOP coverage. However, what you'll see in just a second, what I'd like to highlight are some of the inadequacies of the EPL coverage as an endorsement on the BOP and why it's really important to actually purchase the monoline or the standalone EPL policy. One thing to consider are the limits. So as we mentioned, typically as low as 10K, maybe up to 50 or 100K is what you'll see on the BOP endorsement. Whereas a standalone EPL policy, you're going to get limits up to anywhere between as low as 250,000, maybe even as high as $1 million. Next are going to be the additional coverages. Typically, the EPL on a BOP, this throw-in endorsement as part of a package, is really going to be stripped down. They'll cover discrimination and harassment, but you're not going to get third party, you're not going to get prior acts coverage, and a variety of other aspects to the coverage will be very minimal. Things like wage and hour and third party will probably be excluded altogether. Defense costs being inside or outside the limit. Typically, as we mentioned, defense costs being outside the limit are very important with EPL because the defense costs can really add up and then not leave very much for the settlement or the indemnity. Generally on the BOP, defense costs will be inside the limit. So when you factor in that the limit is already very low, there really is not going to be enough coverage for your average EPL claim. And then prior acts coverage. Standalone EPL policy is generally written on a claims made basis with the option for prior acts coverage. On the BOP, however, it's usually occurrence basis. This could provide a major problem as wrongful acts that occur prior to the policy period may not be covered. Remember, harassment and discrimination often occur over a period of time. And so a standalone EPL policy will be better suited to address any potential unknown wrongful acts. And then finally, risk management services. Usually the EPL coverage on a BOP is just that. It's a throw-in coverage. With a standalone policy, most carriers will provide additional value-added services to help mitigate risk. As I'll mention in just a second, USLI offers a full-service business resource center that can help with an EPL exposure as well as other needs of the employer. More often than not, an insured declines to purchase EPL anyway. Interest will only arise after the first EPL claim, at which point it is much harder for the producer to place the business. And as an underwriter, I can tell you, we were able to provide far more competitive terms when the applicant is claims free. Common questions small employers tend to have. There's a ton of them, but some of the main ones are going to be, how do I fire somebody? How do I hire somebody? What are the appropriate questions to ask in an interview? Should I be classifying this employee as a full-time employee or an independent contractor? California in particular has just made changes to the definition of an independent contractor. And can people waive their rights to a meal break? I can answer that question for you right now. They cannot waive their right to a meal break. That's not something that an employee can just sign away. And so is EPL insurance alone enough? Probably not. But to accommodate this, with every USLI policy, the insured has access to our Business Resource Center. This is a website and hotline that provides pre-employment tenant screenings, identity theft protection, marketing resources, and many more things. But this is especially important as it pertains to EPL coverage. They have a human resources and employment practices consultations. They provide news and expertise on business and HR issues, regulatory compliance information, and information on hiring and firing practices. And just one thing I'd like to mention as far as this particular resource that individuals that have a USLI policy can get. This service would cost an average employer about $5,000 to utilize on their own. With a USLI policy, these services are free of charge. USLI has an average EPL policy premium of just over $3,000. So for what they save on the Business Resource Center access, it really does kind of help pay for itself. So with that, I'm going to kick this over to Dan Mulligan, who can wrap things up for you. Dan?
Okay, thanks a lot, Tim. And like I said, I just had a client tell me the other day that the most important thing that they had was the risk management services in helping them go through the proper channels of terminating an employee. So when you have the EPLI policy, it is just a great tool for them there. EPLI, we have, for EPLI, for most classes, we have a really easy way of getting quotes right now there. If you know what type of risk it is, with no claims there, if you can just send me the information, their name, address, full-time employees, part-time employees, confirmation of no claims, we can get a quote out to you within 24 hours there. And it's, in all the states that we write in there. Some classes are going to be a little bit more difficult. If it's a restaurant or a contractor, then I'll need to send you a full application. But it's for, because those are underwritten a little bit tighter there. You can send that information directly to me at Daniel at CID Insurance. We also have the ability to phone quote where you can actually call USLI direct at 877-969-7539. There, and we give you that information, that number later, where you can call up and get a quote from the underwriters at USLI, and it'll send that quote out to you, instantaneously. It's a great way of getting that policy there. On EPLI, on most classes, if we write it through USLI, we can even pay a little bit higher commission than other carriers and other classes. Most of the time we were paying, 15% commission on this through a USLI group, USLI Mount Vernon Fire Insurance there. Does anybody have any questions that we can answer for you?
Well, if anybody is typing in right now, I want to take a moment and say thank you so much for joining us. And Dan, you want to take that, or Tim, take that? How far back can you file an EPL claim? Tim, you want to take that?
Certainly, yes. So as far as our EPL policy goes, if the applicant has full prior acts coverage on the EPL policy, we'll defend a claim that's submitted for a wrongful act that occurred at any point in their past if they have prior acts coverage. The key thing to keep in mind is going to be that retroactive date or the prior acts coverage on your policy. So any wrongful act occurring prior to the retroactive date, that would come into question whether there's coverage or not. But if they do have full prior acts, we would really, and it's unknown, we would really go back to the establishment of the company as far as responding or triggering coverage under the EPL policy, provided they had that prior acts coverage.
Got it. That makes sense. There is one more question. Could you explain hammer clause a little more, please?
Absolutely. So the insurance carrier is going to defend the claim on behalf of the insured. And what they're going to do is they're going to try their best to reach a settlement with the claimant. Now, with that being said, the insurance carrier cannot settle, at least USLI with a USLI policy, cannot settle without the consent of the insured. So let's say USLI reaches a settlement of $100,000 with a claimant. They're going to reach out to the insured in order to get their consent to go ahead and settle this claim. The insured may say, no, thank you. I would really not like to settle this. I feel by settling this, I'm admitting guilt, and I'm going to stand firm on my position here. As the carrier, USLI will say, okay, no problem. We will go ahead and continue to defend this claim until we find until we get your consent and find a reasonable solution. However, anything in addition to that $100,000, which we were able to reach, we're going to pay 75% of that, and 25% of that, of anything in excess of that $100,000 is going to be on you. So that's what's called a soft hammer, meaning that the insurance carrier is still going to take a certain percentage of those costs in addition to the initial settlement amount. What does exist out there as well is a hard hammer. And what the hard hammer would be that the insured has to pay everything in excess of that settlement amount that they refused. So USLI with their soft hammer will still take on 75% of any additional costs after that settlement has been reached. So kind of, I mean, when you think about USLI having uncapped defense costs outside the limit, the hammer kind of helps to provide a certain level of kind of both having skin in the game in order to settle a claim.
Wonderful, good answer. One more question, Tim. Are class actions typically covered for wage and hour claims?
Yes, they typically will be. And it's a great question too, because as I mentioned, usually if you are doing something incorrectly with one employee, it's probably gonna be across the board. So these multi-employer claims do come up. And yes, that the policy would respond.
Great. Great questions, everyone. I really, that's really important for us to be able to answer your questions. Does anyone have any more questions? And if not, again, I want to thank everybody for joining us today. Tim, thank you for being a great instructor, and you as well, Dan. So please get a hold of Dan if you've got any questions about EPL. He's ready to rock and roll for you. So everyone have a great day, and thanks for joining us.
Thanks, everyone. Have a good day.
Thank you.